Get ready. 3 seconds. 2 seconds. Start. This appeal is in challenge of the order of a learned single judge of the Bombay High Court granting anticipatory bail to respondent 1. When this petition was taken up for hearing, his learned counsel brought to our notice that, in spite of the above order, the Assam police arrested respondent 1 and took him into custody. Thereby, he submitted the appellants have violated the direction of the Bombay High Court in the impugned order. The learned counsel appearing for the appellants, while conceding that respondent 1 was arrested, joined issue with him on the condition that appellant violated the direction of the Bombay High Court. He put forward the stand of the state of Assam for not releasing him on bail. We do not think it necessary to deal with the said controversy in this appeal. If respondent 1 wants to raise that question, it is open to him to move the appropriate forum. As respondent 1 is now under arrest, this appeal has become infructuous. It is accordingly dismissed. Leave granted. State of Assam and its Director General of Police have filed these appeals challenging the orders of Bombay High Court, as per which some officers of MS Tata Tea Limited who are arrayed as respondents herein were granted anticipatory bail facility. It appears that those respondents are suspected to have given aid to militant groups which have been banned under the provisions of the Unlawful Activities (Prevention Act 1967. The Assam police are wanting to interrogate all the suspected persons, including the respondents, in connection with investigation of the cases registered for the above crimes by the appellants. The respondents moved the Bombay High Court for anticipatory bail and a learned single judge, without even affording an opportunity to the appellants for a hearing, directed the appellants to release the respondents, if arrested, on bail of Rs 10,000 each, with 1 or 2 sureties of the like amount. Various arguments have been raised by learned counsel appearing for the appellants in challenge of the impugned orders. Learned counsel appearing for the respondents, while arguing in reply to the appellant's contention, did not dispute that Government of Assam or the Director General of Police of the State of Assam were not heard, in spite of they being met parties in each of the applications for anticipatory bail. According to Sri Tulsi, only the Courts of Sessions in Assam and High Court of Gauhati have jurisdiction to entertain the applications for anticipatory bail in respect of the activities alleged against the respondents, the two banned organizations, because all such crimes were committed within the territorial limits of the state of Assam. We do not think it necessary to decide whether the Bombay High Court has jurisdiction to entertain the applications filed by the respondent. All the same, the questions of granting anticipatory bail to any person who is allegedly connected with the offences in question must, for all practical purposes, be considered by the High Court of Guwahati, within whose territorial jurisdiction such activities could have been perpetrated. In view of the considered position that appellants were not heard by the High Court, we set aside the impugned order on that ground alone. The applications are to be disposed of after hearing the appellants also. For that purpose, we order that the applications for anticipatory bail filed by the respondents would stand transferred to the High Court of Guwahati, where those applications would be heard by division bench of that High Court and appropriate orders be passed thereon.